Helping people get the treatment, the help they need. I worked all the way through COVID. I worked for Ohana. I completed Harbor Hall, Petoskey treatment. While I've been on this probation, before I actually went and did my jail when I was still, and then I went and did my time.
It's all right. I've already stopped paying attention. There's no question. Okay. This is just a narrative. This is not an opportunity, Mr. Johnson. This is not an opportunity for you to ramble. This is how it works in the court.
I've had two people to try come in to pay this, Your Honor. I've tried to come in and pay this in person, and they did not accept the money in Traverse City because I signed a wage garnishment with you guys when I transferred my probation. The only thing here is I just need to come and pay you guys. I can pay you today. I can go into the clerk. I have $60 on me today. I can make a payment.
We're going to take a brief recess. Mr. Harrison's going to talk to his client, get his client to behave, or I'll lock him up for contempt. Stop talking.
Okay.
We are on the record this morning for the 28th Circuit Court for Wexford County. I'm calling the case of the people of the state of Michigan versus Matthew Robert Johnston. This is file 20-12743 Appearances from counsel, please.
Good morning, Your Honor. Corey Wiggins on behalf of the people. And I'm Jeff Harrison. I'm here on behalf of Mr. Johnston.
Mr. Sean Benackwell is before the court as well. He is the agent from the Michigan Department of Corrections here today as the probation officer. Joining us today via Zoom is Mr. Matthew Robert Johnston. Mr. Johnston, can you see and hear the court, sir?
Yes, I can, Your Honor.
One moment. If I look here, I'm sorry, when I look here at the proof of service for the notice of appearance, does say that counsel and defendant must be present. Why is Mr. Johnston not here in person today, Mr. Harrison?
I am not at all certain. I do know that he does not have a driver's license, and this is part of the reason why Grand Traverse County agreed to accept his courtesy supervision. Was a barrier for him as far as reporting to Wexford County in the past. I don't believe his situation has changed. I don't believe he has full-time employment either. He seems to steadily work, but it's sporadically and mostly for cash. He may not simply have the resources, Your Honor. I'm unaware.
Right. So he just doesn't have the resources to be present. All right. Well, if I recall correctly, the defendant has been found guilty of failing to pay his fines and costs. We conducted a hearing. That hearing was conducted.
I was able to make a payment last night to the proper clerk, finally.
Yeah. Okay. Thank you. That hearing was.
I met with my probation. Oh, okay.
We're not going to do this again, Mr. Johnson. It's really getting irritating. This works very simply. You are not here in the courtroom. You are appearing via Zoom. When one person is talking, no one else is doing any talking. I conduct who's talking by pointing out when you get to speak. It is now my turn to speak. We're here today for a sentencing on the probation violation. If I recall correctly, the defendant again was found guilty of violating his terms or conditions of probation by failing to pay his fines and costs. We also had testimony and evidence demonstrating that the defendant is able to pay his fines and costs because he is employed. So we're now just going to proceed with sentencing. Mr. Van Ackle, your recommendation, sir.
Sentencing guideline range on this case is 10 to 23 months. Serving for OWA clerk home. He did pay $30 for his fines and costs yesterday. He continues to owe $1,287.60. That includes the late fee added on. He has 118 days jail credit. On probation, he has completed scram without issue of violation. He has not completed any community service hours. On 11/8 of 23, he was instructed to obtain a mental health evaluation.
I have both of those copies of.
Stop talking, Mr. Johnston. We're done. Mr. Johnston, I'm going to find you in contempt of court. I warned you last time and I've warned you today. You're hereby found guilty in contempt. No, don't talk. Why can you not understand the instructions?
I'm having trouble hearing you.
Well, you wouldn't if you showed up today. I'll deal with the contempt in just a moment. Mr. Van Ackle, you may continue without Mr. Johnson speaking. If he speaks again, we will just mute him. Go ahead, Mr. Van Ackle.
On 11/8, he was instructed to obtain a mental health assessment or evaluation. He has not completed that yet. For sentencing on this violation, I would recommend a continuation of probation with the understanding that there would be additional violations if there's no follow through on the mental health assessment or community service or additional failure to pay for fines and costs.
What was the length of probation that he was originally set for? Was it 36?
$36 months.
36. Okay.
Was projected discharge date, I believe, would be 8/6 of 24.
So your recommendation is to continue probation as previously set, preserve the fines and costs. I understand the fact that the defendant has not conducted the mental health assessment and has not conducted any community service. You can't necessarily sentence him for those since he hasn't been found guilty of those. But of course, Mr. Johnston can hear that he must comply with that assessment and he must complete his community service. All right. And do you have any recommendation regarding confinement?
No recommendation regarding confinement, Judge. I'd just defer to the court for that.
Thank you.
Again, he does have 118 days credit.
What was his original sentence for days? What's that?
118.
Is that what it was, Mr. Wiggins?
That's what my notes reflect.
All right.
Yeah.
All right, thank you. One moment. All right, one moment. Let's go ahead. All right, Mr. Wiggins, on behalf of the people, sir.
Thank you, Your Honor. As the court indicated, that you found that he had the ability to pay and hadn't paid. We did set some time for him to pay, and if I recall correctly, from before, he was saying he could pay it all off, and we received a $30 payment. On top of that, he did not follow the court orders to be here today. I specifically remember the court telling him that he had to appear in person. I'm going to request that, along with Mr. Van Ackle's recommendation, I'm going to request 15 days confinement.
Mr. Harrison.
I would like to put some perspective in play here. The perspective is, yes, it was only a $30 payment. I'm actually happy that he made that payment. Now, it might have been the dollar amount that he had insisted he could pay, or it certainly wasn't timely based on the violations. However, it represents, at least in my eyes, something that had been lacking up to then, that of recognition that the obligation is owed to this court. So it seems as though we've crossed what is frankly a rather significant hurdle in dealing with this entire situation. I have spoken to the probation agent in Grand Traverse County as well. He too is concerned with perhaps Mr. Johnston's state of mind and supported the recommendation or the requirement that he obtain the mental health screening that was previously discussed. If the court assuredly will recall, there was a great deal of confusion expressed by Mr. Johnston in the initial couple of appearances in this matter. I'm actually encouraged by the fact that at least one of those issues is apparently resolved in his thinking, that he is now aware of and is at least making some, albeit minor, progress toward resolving the payment that had been lacking in the past. It's a standard kind of concern that I have, perhaps amplified more so in this case. Putting him in confinement and taking him away from whatever employment opportunities he has is be terribly counterproductive, not only to his ability to pay, but his sense of obligation in that regard as well. Thank you.
Mr. Johnston, now it is your opportunity to provide a statement. Is there anything you wish to say regarding sentencing, sir?
Just that I'm doing my best to make everything right, and I've met with my probation officer here in Traverse City. He's also aware of my attempts to right this issue and to pay it off completely. I was unaware which clerk to contact, Your Honor. Once I got that straight, I made a payment immediately. But other than that, I apologize for any time spent on my behalf with this issue, because I tried to clear this issue up the day I was released out of jail so it wouldn't present itself at all, Your Honor.
I'm not really sure what that means. If you were trying to clear this all up when you were released on jail so there wouldn't be any issues, you would have paid your fines and costs then. You would have known where to pay your fines and costs because it was only 5 blocks away from where you were released from jail. Mr. Johnston, all I've heard here are excuses upon excuses and how it's everyone else's fault other than your own. Now, ironically, there's one thing I don't know if the parties have picked up on. If I give the defendant 15 days, which would be a sentence of 133 days, he has 118 days of credit. What's the one thing he also gets?
Well, the good time would come off of that. He gets that back.
Which means he won't serve any time.
I understand. That's
so it's Mr. Johnson, let's be real clear. This court does not buy much of anything you've had to say. Mr. Van Ackmel has highlighted that he can bring, and whether or not he chooses to do so is his own choice, additional probation violations for your failing to comply with your community service obligation, and your assessments for mental health. Those are things he can bring. And if he does, the next time, the court would be looking at up to 45 days. So I want to give this defendant the additional 15 days. The court sentences the defendant to 133 days of jail. That's the 118 plus 15.
Okay.
The court gives the defendant 118 days of credit. Now the question here is does he actually turn himself in on that case? How does the jail establish the good conduct time credit? Mr. Van Ackle?
Would you like me to call the jail and inquire real quick?
Yes, because then if so, I think one way I can take care of this on paper is to then give him that good conduct time credit as well. But I don't know how I do that because he'd actually have 20 days of good conduct time, right? Almost 20.
Or 4 months, thereabouts, yeah.
Right? It'd be 4 months, it'd be a little less than, so I'm really just questioning here what to do with the paperwork. The other, I don't want to call it a white elephant in the room, but the court has found the defendant guilty of contempt. And I can always add some jail for that, which I'm considering, because I've gotten tired of Mr. Johnson interrupting the court. Now, I could always reverse that finding of contempt. I know very well that there's a very strong language within the judges' associations about using contempt power sparingly. And so I might calm down here. I'm sorry, not as emotional. I'm trying to figure out how to deal with somebody who keeps interrupting the court. Mr. Wiggins, any input? Because we're kind of at a conundrum here, that it's only 15
I am
days.
as well.
I agree, Your Honor.
Typically, it's the jail that assesses the good conduct time and then adjusts the release time.
Off of the top of my head, it seems that he would have to at least check in order to
Get his
begin
good time.
serving the sentence and then have the time
Yeah.
accumulated.
Yeah.
Because otherwise, the jail's not going to have a record that he has, because then he would also, in theory, then would.
It's my thought as well. He has to turn himself in, and then an effect would be released within the hour of turning himself in. This is just a bit of a conundrum that I haven't dealt with. I think he has to turn himself in to be able to establish getting his good conduct time
I
credit.
think it's a formality that perhaps the change in the law did not address in any significant way. So we are kind of left to fend for ourselves.
Yeah. All right. So here's what we're going to do. The court, again, continues with its sentence on the probation violation. The court sentences the defendant, as I've already stated, to the 133 days. And the court grants 118 days of credit. The defendant must turn himself in to the Wexford County Sheriff Department today by 5 p.m. How he does that is not the concern of the court. The court continues probation as previously set by this court and preserves all fines and costs. While not a part of the sentence, the court reminds the defendant that apparently he may be in violation of his probation or delinquent in completing some terms or conditions of his probation. And he should contact his probation officer. If he has any questions, he should always contact the probation officer here in Wexford County and or his attorney here in Wexford County. Now, As to the contempt issue, the court is not going to sentence the defendant to any period of jail or any fines and costs. I will let the contempt finding stand, but I'm not going to add any penalty. It might seem to be a bit unnecessary, but the court will let the contempt finding stand because the court is in charge of the courtroom and must do all it can to respect the dignity of the courtroom. And that's the message being sent by the finding. But based upon all the information I've heard, I don't think I'm going to add any jail to the defendant's sentence. All right. Anything else, Mr. Van Ackle?
No, Your Honor.
Mr. Wiggins?
No, Your Honor.
Mr. Harrison?
No, Your Honor. Thank you for the accommodations you've expressed on behalf of my client.
Mr. Johnston?
Yes, sir, Your Honor.
Thank you. You have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney for you, you must turn in a form that will be provided to you through your probation officer and request that within 42 days from today's date. Now, in effect, I understand that you probably won't actually serve any time in jail, but you must report to the Wexford County Jail today by 5 p.m. I anticipate that they will calculate your good conduct time credit. And if you have not lost any good conduct time credit, you should most likely be released again today. I'm acknowledging that this might be a bit of a inconvenience. I'm going to let that stand because I want the message to be sent to that inconvenience, I guess. One last go around. Anything else, Mr. Van Ackle? Anything else, Mr. Wiggins? And Mr. Harrison?
Nothing further, Your Honor. Thank you.
Mr. Johnston, if you do not have yourself turned in by 5 p.m. today, you could expect potentially a bench warrant to be issued. And you could also expect that that would be a violation of court orders, which could itself be a probation violation. Thank you. We are.